Hi, this is Rain. Sounds like green. I'm a Minnesota realtor and I help families get through probate with more money and less stress. Today I'm joined by Minnesota attorney Jesse Griffin from the Bolt Law Firm. Jesse, welcome to Probate Help Desk podcast, and please take a minute to tell us about yourself and your work.
Yeah, glad to be here and thanks for having me. My name's Jesse Griffin. I am an estate planning, elder law, and probate attorney. My office is in Anoka, Minnesota. We're right next to the courthouse here in Anoka, but I practice throughout the state. I'm at the Bolt Law Firm. We've got 10 attorneys here. There's a few of us that do estate planning and probate, and then we also have some personal injury attorneys that do personal injury work, car accidents, slip and falls, that sort of work. So we have a diverse practice here, and we're just trying to help people out. I specifically focus on helping out families with their estate planning needs, and if needed, helping them go through the probate process.
Sure, and Jesse, I noticed that on your website it shows that you also do community education classes in Anoka. What inspired you to start reaching out and doing community education?
Yeah, we found that educating people once they know what they don't know, it's a very simple decision for them to say, yeah, I should really hire an attorney. I should get this taken care of. Once people start to hear about what could happen if they don't do some planning, it really drives that point home. I think underlying, everyone knows, oh, I should really have a will or a trust or a healthcare directive or power of attorney, and it's something that's easy to put off. And then once people learn a little bit more and hear, a lot of those classes kind of turn into horror stories of what you don't want to happen, and people are it bumps it up on their priority list once they hear some of that stuff. So we actually do community ed, not just in Anoka, but in a bunch of the surrounding areas. We do it up in Cambridge, we do it down in Roseville. So we do a bunch of the area community ed classes to help people learn about these topics.
Absolutely, and just to name some of the courses, I might attend a few of these. They look great. One is Understanding Trusts. You have another one called Keeping the Family Cabin, one called Write Your Own Will, Write Your Own Healthcare Directive, and then everything you need to know about estate planning. And just out of curiosity, Keeping the Family Cabin, that sounds really interesting. Can you give us a little preview of what you cover there?
Yeah, for sure. So it's in Minnesota specifically, a lot of cabin owners,
Mhm.
and it's one of the things that becomes highly contested, especially amongst families that maybe don't always get along the best.
Yep.
And even amongst families who do have a really cordial relationship, a cabin can often become a really fractured piece of property. Mom and dad leave it to their four kids, and then those four kids leave it to their kids. And by the second or third generation, we've got 16, 20 owners of this property. And that's just tough to manage even in the best of circumstances. So that class and the planning we do around it really helps try to avoid some of those issues and help put a really clean structure in place to make sure that we don't have one person out of those 20 forcing a sale, or they become bankrupt and now all of a sudden we're selling the cabin to pay for a 1/20th person's interests bankruptcy. So those are the sort of issues we're on the lookout for in that planning in that class.
That's a great example. As you know, I'm also in Minnesota, and I know people in Minnesota that have gone through the exact scenario that you just mentioned, right? A great grandparent or grandparent own the cabin, and it gets passed down to all their children, and before you know it, you have a family of, cousins and second cousins that are sharing these cabins and land and all these other things, and then in one case, they felt like it would cost them more than each share in order just, to get out of it. And so doing that planning in advance is a great idea. Um,
And those sorts of cabins too often fall into disrepair because one person goes, I'm not going to pay to put a new coat of paint on or fix the deck that's fallen off because everyone should contribute. And then another owner is like, well, I hardly ever go there. I'm not going to kick in money to fix a deck that I don't ever go see this cabin, and then nothing ends up getting done. And so over the course of years and enough things break down or start to break down, and the cabin falls into disrepair, and then no one wants to use it. So it's a really
Sure.
sad situation, honestly.
It really is. And related to that, I've also seen scenarios where the family is sharing the cabin, but they put it in one person's name and then they have a falling out. And those who are not on the title come back looking for their share, and they're not on the title.
Yeah, yeah, they can certainly get really messy.
Absolutely. And speaking of that, I also noticed that part of your background is in civil litigation. You have years experience in civil litigation. And one of the questions that I wanted to ask, a lot of times family are approaching us online and in person, um, talking about litigation during probate. And how do you advise a family or determine if it makes sense for them to pursue litigation or look at something else?
Yeah, for sure. So my civil litigation background started, I was doing class action lawsuits,
Mm,
mostly centered around pharmaceuticals and medical devices. So when I switched my practice area to probate and estate planning, because of that background, I wasn't afraid to tackle some of those messy litigation cases. And I found that there's a lot of estate planning and probate attorneys who don't like to deal with anything contested, including the other attorneys here at my firm. They'll handle a clean probate. They'll go through the process with a family where no one's fighting about anything. But the second it turns into a situation where siblings are at each other's throats, they're sending it over to me because they know I don't shy away from that sort of case. Um, as far as when to advise families on what route to take, um, I mean, that's going to vary obviously for each
mhm.
situation, but after doing it long enough, you start to get a feel of when this is a kind of a petty squabble that we can resolve with, some creative thinking, and when it's really something that we should, all right, well, let's just file an objection and we'll move forward down a litigation path because I can see the writing on the wall already that this is where it's going. Um, but there's a bunch of different factors that play into that, and certainly I like to avoid that, right? It only increases the costs for everyone, and we end up spending, I mean, I, I end up getting more of the estate than other people do because they're paying me to fight about it, and I don't like to see that for families. I'd rather have it be a clean situation, and if everyone can get along, that's certainly best for the parties involved. But these sorts of situations are prone to um, people feeling like they need their day in court, and sometimes it's just that's the way it's going to go.
And you bring up a really interesting point, and I've heard this from other attorneys, and I've experienced it myself as well. With your litigation background, a lot of times you can use that to keep families out of litigation, and that's amazing. I know when I was personal representative, I thought we might be heading towards litigation with some of the other interested parties, and I was preparing for that, and the attorney that I was working with was able to avoid it completely, and also help us salvage our relationships in the process.
Yeah, and that's something um, that is a big factor, right? If you do proceed down a litigation path, it often fractures relationships beyond repair.
Mhm.
And so that's something I do counsel a lot of my clients on is certainly you have the legal right to pursue this path, but just keep in mind that one of the consequences of doing that is you may never again talk to your brother, or Christmas is going to look a lot different going forward, that sort of thing. And that's an important factor to consider. Sure, maybe you feel like you were cheated out of X, Y, or Z, but at the end of the day, is it worth throwing away the family dynamic for? And maybe it is, maybe
Right.
it's not, but that's certainly a factor to consider. There's, other civil suits, right? If you got a breach of contract case, it really comes down to dollars and cents. When you're in the probate world, there are all sorts of family dynamics. There's emotions at play, and it takes on a bit of a different element because of that.
Absolutely. And Jesse, are you do you work then with the personal representative who is responsible for the estate in some of those litigation matters, or sometimes are you also working with family members who might want to pursue litigation against the personal representative? Do
Yeah,
you?
certainly I do both. So often oftentimes I'm helping represent the personal representative, helping them understand and walk through what their legal responsibilities and duties are. But
Mhm.
I do have situations where one of the other beneficiaries approaches me and maybe we're a couple years into the probate already and they say, hey, this personal representative is not doing what they're supposed to do.
Mhm.
And I can get involved to either, oftentimes that starts off with a demand letter to them and say, hey, this is what you're supposed to be doing. And if you provide these things to us now, we can avoid getting deeper into this. But sometimes it does involve bringing an action in court against that personal representative. And I've certainly represented beneficiaries in that regard as well.
Absolutely. And have you also run into the beneficiaries who want to take action, but then they don't want to assume the role of personal representative?
Yeah. Yeah.
Yeah.
And in fact, a lot of times when it gets really contentious,
Hmm.
it serves everyone's best interest to appoint a neutral third party to take
Hmm.
over.
Hmm.
There are fiduciary companies, there are banks that will have a fiduciary role that can step in and they're neutral and unbiased and they just take over and look at it from a completely unemotional and clear perspective of these are the assets. These are what people are entitled to under the documents. Let's take care of getting that done and can strip away some of the family dynamics that come at play in these circumstances.
Absolutely. And you've talked about the family dynamics. What are some of the other challenges that you see for families going through probate?
Yeah, I think one of the biggest ones is the unwritten agreement or the unwritten understanding. This is always what mom wanted, and then she passes away, and we can no longer verify with mom if that's what she wanted. And if we have no documentation to prove that, the law says this is what we're supposed to do.
Hmm.
And then once the person who benefits most from it hears that this is what the law says we have to do, if I don't agree otherwise, then this is what's going to happen. And then the unwritten agreement is out the door. Um,
Yeah,
so that's often a big challenge and trying to navigate that, or just people not understanding, if someone gets married, right? So a new marriage, right? Mom or dad got remarried towards the end of their life, and the adult children don't have any relationship with that spouse, and that spouse has certain rights just by virtue of getting married.
hmm.
So that's a big challenge. And then a part of my practice too is elder law. And
Hmm.
what I mean by that is um, towards the end of life when people need more assistance and we're going into long-term care facilities, which are very expensive. The average monthly bill at a long-term care facility is eight to $12,000 a month.
Mm, wow.
So figuring out how to navigate paying for that bill and what assets make most sense to use first. How do we spend our assets and get on to long-term care assistance through the state are all things that are really crucial questions. And we do some planning around that. But oftentimes we find ourselves in a situation where mom or dad needs care, they go into a facility and we're spending all of their assets paying for care, and the kids feel like they are entitled to that. And you have to navigate the idea that, well, mom or dad are still with us, we need to use their assets for their own care. And at the end of the day, you may not receive anything, especially if we haven't got some planning in place that helps protect some of those assets. So.
Absolutely. And when you are speaking of planning, I know you're talking specifically about elder care, but is part of that planning toolbox the estate planning that you do? Is that?
Correct. Yeah. So ideally, right, we meet with everyone when everyone's healthy and everyone's on the same page and everyone agrees on what can happen, and we can put some valuable planning tools in place. We can put a trust in place, or we can put powers of attorney in place so that when we get to these situations, when we have a long-term care event, we've got more options, more tools in our tool belt to work with to help prevent the worst situations. Having documents in place to help avoid some of these messy probate situations we talked about. We alluded to earlier the keeping the cabin in the family, right? That's a planning tool. All of the nightmare scenarios we talked about can be avoided by putting in place a cabin LLC or a cabin trust that can help avoid all of those pitfalls. So ideally, right, I would have no probate clients and everyone would be an estate planning client. They'd come in, we'd get everything in place, everything would be smooth and easy to administer, and everyone's happy. And obviously that doesn't always happen, and hence the need for some of the probate and the litigation that ends up happening. But I do think if everyone fully understood where things could go, they
Mhm.
would get their estate plan done, and we can avoid a lot of the heartache that families do go through.
It's funny that you mentioned that as a realtor who works in probate. One of the questions I am most commonly asked by people in probate is, how can we avoid probate? And but you're in it. You're already
Yeah, I mean, I
there.
have found that it's very common for I'm helping out the PR go through probate for mom and dad, and then as soon as that's done, they're in the next week to get their own estate plan done, so they
Yep.
don't, subject their kids to the same thing that they had to go through. I often tell people, losing a loved one is hard enough without
Hmm.
having to go through some legal complexities. There's enough of an emotional toll and just uh, even with a straightforward plan, there's still a lot of administrative work that has to get done in the cleanest of circumstances. So avoiding legal entanglements, pitfalls, and a lot of delay that comes with that can really help smooth that process over and make it as easy as possible for a situation that's never going to be easy.
Absolutely. And we lived through that exact scenario that you just talked about. When my father passed away, he had a will, didn't realize we would still have to go through probate, and we experienced the all the joys and frustrations of probate. And after my mother saw what we had gone through, she went out and did a trust right away. And
Yeah, that's one of the biggest misconceptions in this world is that when I say this world, I mean the
Mhm.
estate planning world, is that if I have a will, I don't have to go through probate, and that's not true. A will is just instructions that the probate court will follow, and it's just one of the tools we use, and we need some other tools in place to help avoid probate. And so, a lot of people think, oh, mom's got a will, we're all set, and turns out mom could have used some other things to help avoid probate.
Absolutely. And you talked about the elder care and the estate planning. So what is the process if someone is working with you? How do they get started with their estate planning?
Yeah, so we start out in our estate planning cases with a free initial consultation. And so typically someone will call, they'll schedule an appointment, and then we send out a questionnaire packet that asks a bunch of questions about what are the assets we're talking about, who are the people involved, are there kids, spouses, all of these things. And then I sit down with that client and we go over everything. We talk about all of the questions that could have a bearing on their estate plan. Are there kids? Do any of the kids have any sort of disability? Is it a second marriage situation? Is there grandkids? Are there charities that we want to leave anything to? What are the assets we're talking about? Is there a collection of some kind? I found collections are a big source of controversy, right? The
Hmm.
stamp collection, or dad's got some, antique guns or something like that, and one or two or five siblings all want those things, and they become a source of contention. So these are the things we're talking about and asking about. And through the course of that meeting, the initial consultation's a little bit investigative. I'm asking questions. I'm trying to get a full sense of the scope of the situation we're talking about, and then partially educational,
Hmm.
where I'm teaching the client about what are the tools we use, what are the benefits of this tool over that tool, and going through a lot of the same things I teach in that community ed course, so that they can understand and make an informed decision about what they want to do and what approach they want to take.
And did I hear you say that that initial consultation is free? You offer that as a free service?
I do, yep. So,
That's
and
amazing.
yeah, and for the same reason I was just referring to with community ed, right? I find once people know what this landscape looks like, they're quick to want to get things taken care of and actually put in place. So
Mhm.
I hope that people come in for that initial consultation and aren't scared off by an invoice from an attorney. That's why we do it as a free initial consultation. And then once they've learned everything and we've talked about what could happen if they don't have some planning in place, I find most of the time people are eager to move forward with getting those things done.
Absolutely. So they would contact you. They would then fill out the packet or the questionnaire that you would send them, and then they would come in for a free consultation, and you would assess their situation and determine some of the best tools to use. And
Absolutely, yeah.
and in the process, save them thousands of dollars in the future that they're not even thinking about.
Correct, yeah.
Oh, wow. And then how about the ongoing process? Do you encourage your clients to come back for checkup on a regular basis?
We do, yep. So we typically recommend every 3 to 5 years you have your estate plan reviewed. On the more often end, if things are changing rapidly, or maybe a little less often if things are pretty stagnant. And then we also will send out letter updates when there's big law changes. So
Mhm.
um, in the real estate world, you're probably aware of the transfer on death deed legislation that just passed in the last year. And we sent out a big letter to a bunch of our clients and had hundreds of people calling saying, "Oh, I need to get this updated or changed." And so we try and keep people up to date on the big changes that may affect their plan
Mhm.
and recommend that people do review their plan either with me or another attorney at
Sure.
some relatively often frequency to make sure that as things change, their plan's updated.
Sure. And I have also run into situations where a family did not update their plan. And then maybe, maybe mom and dad got divorced and now there are stepchildren involved and the dad passes away and the stepmom is the trustee and a beneficiary and it's, nothing's been updated and the new children and the new spouse are really upset. How do you untangle that? I mean, I would imagine it depends on each case, but do you have any
Yeah.
any advice for people that might find themselves in that situation?
So the biggest piece of advice I have for people is call your attorney
Hmm.
when anything changes. So I tell my clients at the end of a meeting where we sign all their documents, call me if anything changes. And if you're not sure whether it affects your estate plan, call me. I'd rather talk to you and say, nope, that's nothing we need to worry about. We don't need to change anything for that event
Hmm.
than to have it go the other way where you don't call me and it is something we should have updated. So the first piece of advice is when in doubt, call your attorney and they can tell you and they can help assess whether an update needs to be made or even to help you weigh the pros and cons of making an update.
Hmm.
Sometimes people will call and I'll say, yeah, best practice would be to update it, but if we don't update it, it's not that bad of a situation. And here's the worst case scenario, right? And they go, okay, yeah, I think I'll wait rather than spending some money on updating it. Or I tell them that and they go, oh, we want to avoid that completely. Let's get this updated right away. And it's always better to be able to have that conversation than to have the person making that decision for themselves and not getting that legal advice. So
Absolutely. And so the estate planning is a very important tool prior to probate. If someone had a will with no plan or they didn't have a will at all and they find themselves in probate, what's one of the bigger challenges you see for some of those families going through probate?
yeah, I mean, especially when there's no will at all, the issue comes up of, all right, we've got three kids and all of them think they should be in charge. And
Mm.
so right out the gate, we've got to fight about who's even going to be the personal representative, much less about what are we doing with any of the specific assets or anything like that. Um, and then even when there is a will in place, oftentimes the biggest issue is delays.
Hmm.
We've got, mom passes away and we've got a house and the house needs to get sold, but they can't do anything until there's a personal representative appointed.
All right. Yeah.
And the courts are, backed up and you file a document. I filed an initial petition this week and we've got a hearing scheduled for April for it. So that just gives you an indication of, all right, we're sitting around an extra 3, 4, 5, 6 months sometimes before we can even sell the house. And in the meantime, we've got utilities that need to get paid. We've got a mortgage often that we need to be paying, insurance on the property, and all of that money is just going out the door and could be avoided if we had a document in place like a trust that would allow us to sell the house more quickly. So even in situations where everyone gets along and no one disagrees, just the mere fact of having to go through the probate process, and it's almost like the court becomes the enemy because they're just taking long and it slows the process down and it's expensive. The
Yes.
average, the average uncontested probate in Minnesota costs a family about $5,000 to $10,000.
Hmm.
And so if you can avoid that, even with a trust that might cost you a couple $1,000s, you're saving the family money in the long run.
Yeah, and it's, they just don't always realize it until they're in that situation. It's so challenging. Um, you said something I was going to ask you about the family. Oh, when you were talking about scenarios where there is no will and there might be three siblings or three heirs. Um, do you encourage them to settle on one personal representative, or do you encourage them to share the responsibility?
I always encourage one personal representative,
Hmm.
whether that's when we're planning and I'm talking to people and they say, oh, we'll put all three of our kids in charge. I try to convince them that one's a better option. Or if they're in that situation where it's the three siblings and they're trying to figure out who, I always encourage just one. um, both from a logistical standpoint, right? We don't want to have to get everyone together and go to every single bank. All three of you have to sign this document now. So just from a logistical standpoint, it creates some headaches. And then if there's any disagreement, it's better to just have one person in charge that says, I get to be the final arbiter of this decision. Now, hopefully that sibling consults with their other siblings and say, this is what I'm thinking about doing. Does anyone have a problem with that? But having multiple people can really grind things to a halt. And, if we've got one holdout amongst that group of three, we find ourselves having to go back to court, which means more delays and
Yeah.
and have that resolved by the judge rather than saying, okay, we've got the one person in charge and they get to be the final arbiter of those decisions.
Yeah, that's great if you can get that worked out up front. It really does save a lot of headache further on down the road. Absolutely. And the other thing I was thinking about as you were talking is you were talking about maybe they don't get started or they don't realize that they need to file for probate in order to sell the house. And I see scenarios like that sometimes with traditional realtors who don't understand the probate process. And they might even go ahead and list the house. I would argue that that's not a valid listing agreement, but that's another episode, I think.
Yeah.
But they'll go ahead and then they have the buyer and they start the process with the title company, and the title company says where are the letters of administration, and there are none because they didn't file. And can you talk about what happens then?
Yeah, I have encountered that exact situation as well, where we've got either a listing agreement or even a signed purchase agreement,
Mhm.
and all of a sudden we're going through the title process, and they go, "Wait, the house is in Dad's name, and Dad passed away 2 years ago. What's going on here?" And all of a sudden, I'm getting the phone call from the title company, and they say, "We've got a closing scheduled for Friday." And I say, "Well, good luck with that."
Yeah,
No,
yep. It's true. It's true.
I, there are some options we have. There are some emergency procedures you can file. So I have been able to step in some of those circumstances and save a deal. by getting an emergency order signed. And then typically what happens, right? We submit for an emergency order, the court signs it. We get the closing done so we don't lose that sale, but then we have to go back through and start the probate process from there. And that money's sitting in an escrow account somewhere.
Yeah.
So you're not gonna short circuit the process by doing that. You're gonna end up waiting anyways. So it's usually better to have that stuff done earlier rather than paying me for an emergency proceeding and then also the probate proceeding. But there are things that can be done in those circumstances, but it it creates a lot of fervor and a lot of hectic phone calls and people, driving
Hmm.
documents all over the place and getting certified copies from the court. And we need you to come in right now to sign this, transfer deed. And it's better to avoid those where possible.
Absolutely.
But it happens all the time where people go, oh yeah, mom passed away. It says right in her will that she leaves me the house, but that doesn't actually transfer the title.
Right.
And so, I mean, I've had situations where we're on our third or fourth generation of that happening, and we look at the title work, and title was in great great grandma's name,
Hmm.
from 60 years ago. Now we're filing 4 or 5 different probate proceedings to chain that title down to the person who's trying to sell it. And
Wow.
it it creates a lot of delays through the court, a lot
Yeah.
of administrative work, and frankly, people pay a lot of money to me and other attorneys to handle that. And if you can avoid that by getting some planning done or contacting an attorney right away and getting it
Hmm.
taken care of, it avoids a lot of issues.
Well, and that's where you start to see the scenario with cousins and distant relatives popping up, or worse, you're obligated to contact them in some of those situations. And and they say, "Hey, go ahead and sell the house. I just want my share." And the person
Mhm.
living there says, "Wait, I've been paying the property taxes for the last 20 years. What are you talking about?"
Yeah, and oftentimes, right, we're chasing down, you know, Uncle Bob's 4 kids that we've had no contact with ever,
Hmm.
but because Grandma left it to her kids, and Bob was one of those, and Bob's passed away now. His kids have a share in
Yeah.
the house that we thought was, just ours. So yeah, it can create. I just did a probate last month that had 48 heirs that we were having to locate, having to get to sign off on selling the house, and like like I indicated earlier, even in the best of circumstances, that's a logistical nightmare. And if you have any one of those people are holdouts,
Right.
then we are are doing other proceedings and we're talking about litigation or we're talking about paying those people off to get them to sign an agreement. So
That's one of my favorite go-tos, Jesse. When it works, I love to. And the families I work with don't always appreciate that. And sometimes we end up in these scenarios where maybe we have a family going through probate pro se without an attorney,
mhm.
and so no will, no attorney, and then they insist on using their own title company, and maybe it's a title company that doesn't really fully understand the process. Um, wow, I
That's
yeah.
one of the big values of hiring a professional like a realtor or a competent title company or an attorney is then you don't have to go through it to appreciate the pitfalls that can come up.
Yeah.
Your
Yeah.
attorney or your realtor has seen it before and they can warn you that, hey, we should really do it this way because this is what I've seen happen before and you want to avoid that.
Well, and one of the things that I will do in that situation is I will not only share my past experiences with them, but then I will encourage them to hire an attorney to either complete the rest of the probate process or at least get through this issue that's you know in our way, because it's there's nothing worse than thinking it's a slam dunk easy probate case and then later on they find out that it really wasn't.
Yeah.
So
E- e-
pay the attorney up front.
Even the easiest of probate cases are worse than a trust administration. So I always tell people you want to avoid probate, even if it's fairly straightforward, it can still be a nightmare to deal with.
Absolutely. Jesse, one question I have for you. I have not asked any other attorneys this question, but when you set up a trust for somebody and you are and you have that, trust fund, I believe the term you use is funded. Is that the
Yep,
correct term?
funding.
So you funded the trust and it's a legitimate trust. At that point, if the family needs legal counsel, are you representing the trustee, the trust, or who do you actually represent in that situation?
Yeah, so it depends.
Okay.
Uh, but attorneys represent people. So an attorney wouldn't represent the trust itself.
Okay.
You would represent the trustee in
Hmm.
their role as trustee. And so they've got obligations to make sure they follow the trust. And so in a way, you're kind of making sure that the trust is followed because you're telling your client, who is the trustee, hey, you have a legal obligation to follow what the trust says, meet your fiduciary duties. But you represent a person. You represent the trustee. I can represent a beneficiary of the trust to make sure that everything's being followed and that they are, you know, that they have certain rights as a beneficiary, that they are utilizing those rights and are getting what they're entitled to. Um, so it depends on the situation. I could represent either the trustee or a beneficiary, or the initial grantor who creates the trust.
Mm,
Um, but but attorneys represent people. You can't represent the trust itself.
not an entity. Okay. And so I would assume the same is true then in probate. If the personal representative hires you to help them get through probate, you would be representing the personal representative and not all the family members.
Yeah, correct. Yep. So it's a similar idea, right? You don't represent the estate as an attorney. You could represent the personal representative in their role.
Hmm.
And so in that same way, you're telling them that they have a duty to fulfill their role as the personal representative and make sure the estate is legally administered, but you're representing that person, or you represent a beneficiary of the estate. Um, and you can represent multiple parties, but a good attorney is going to make sure it's very clear who they're representing
Hmm.
and what the scope of that representation is. So in
Um,
those situations where I do represent multiple family members, I make it very clear I'm representing everyone here. And they all sign a joint representation agreement. So they know that I represent not just them, but I represent them and their sibling or whatever the case is.
Absolutely. I think that's a common misconception that I see online a lot is people giving other people advice to contact the attorney because the attorney represents the estate. And then they'll come back frustrated in the Facebook group or wherever, and they'll say, the attorney won't talk to me.
Yeah.
you know, and in some cases, it might be good that the attorney's not talking to them because, confidentiality and racking up bills against the estate and
Yeah,
all. So,
definitely. I always recommend, so what's decently common is I'll sit down for an initial meeting with, mom passes away, she's got three kids, all three of the kids want to come meet and hear what I have to say. And I go through the whole process with them, but then I tell them I'm going to be representing, Steve as the personal representative. And I recommend that you guys funnel your questions to him and he contacts me. Because if everyone's calling me, first, you're running up extra bills. And second, I'm going to tell anyone but Steve that I can't talk to them. I've got to talk to my client. Or
absolutely.
even if he says, yeah, go ahead and talk to them, I still have to then turn around and call him and say, hey, your sister called and this is what she said and this is what I told her. Based on you telling me I could tell her that. So it creates duplicative billing. You're getting billed for the phone call with the one sibling and me calling the client afterwards. And you can save that by just having all the calls funneled through the personal representative.
Absolutely. We are coming to the end of this interview, and one of the things I would like to just to recap, you talked about elder care, you talked about estate planning, and you talked about probate, and you work in all of those areas. And we will put a link to your website in the show notes. And is that also the best place for people to find out about your courses? Where would you like them to go to find out about your courses?
Yeah, those courses are taught at the, like I said, the various different community education facilities throughout the metro area here. And typically you can go to, for instance, the Anoka Hennepin Community Education page. That's where those courses are listed, and when and the times they're taught, it's all there. So certainly, those that would be the best place, and that's where you can register for all that stuff too. It's easier than contacting me. I
Okay.
have my office direct people to them directly anyways. So if you're looking for one of those community ed courses, I'd recommend just looking at your local community ed. If it's not one that I teach or our office teaches, um, I'm pretty sure every community ed has similar courses taught by attorneys throughout the metro area here.
Yeah, and my wife and I were looking at your courses in our local catalog, and it was very easy to find, and the it just they look like great courses. So appreciate that. As we get ready to part, is there any other advice you would like to leave for some of the families that are watching today?
Yeah, I think the biggest piece is contact an attorney if you have any thoughts or worries about it. You're better off talking to someone and ruling out whether you need to hire an attorney or not, rather than trying to make that decision on your own. There's just so many things that most people don't know, right? We've got the known knowns, the known unknowns, and then the unknown unknowns, right? The things you don't know. And those are the things you find out about from the attorney. So call an attorney or call your attorney and just run that question by him, and you're better off, paying for a phone call if your attorney charges for phone calls, or paying an initial consultation fee, than to find out later down the road when there's nothing we can do about it and we're stuck going through probate, or we're stuck dealing with a much worse situation because you didn't think to contact the attorney, or you wanted to avoid, an invoice.
100%.
Um,
And I would rather have everyone call you before they call me, Jesse, because because we run into those scenarios, right? They don't know what they don't know, and we run into a problem with probate or the deed or something where an attorney could have steered them in the right direction very quickly. And but they find out later on down the road, and it costs time and money in many cases.
yeah, my clients that are on the estate planning side that are doing planning ahead of time typically pay way less than my clients that are coming to me after the fact and we're cleaning up a mess.
Mhm.
So I tell people the that they're going to pay at some point in the process. And if you want to save yourself money, you're better off paying to do the planning ahead of time.
Absolutely. Well, Jesse Griffin from the Bolt Law Firm in Anoka, Minnesota, we really appreciate your time today. Thank you so much for sharing all this incredibly helpful information. Thank you.
Absolutely happy to do it.